Well, as we wait for people to join, I want to thank them for coming, and especially during these difficult times. As we see people increase, we're now. So we're going to wait just a few minutes to let people sign on and come on. And really want to thank everyone for taking their time. So at 150, when we get to about 200. So normally this time of year, I'd be saying how the Cubs going to do, the White Sox. Can't do that. And what's that team down in Texas?
Well, there's several teams down in Texas. I follow University of Texas myself.
Well, I'm a Badger, so it's at Wahoo.
Baseball.
Hook 'em horns, Richard. Hook 'em horns.
There you go. They say baseball may come back in the summer.
Oh, that's what they're saying. So that's an interesting labor issue, Michael.
So we've got a team down in Houston that has some interesting legal issues.
Boy, they happen to get caught.
I think the defense is everybody does it.
That's what I hear.
So when we hit 200, shall we begin?
Sounds good to me.
Okay, because we don't have a huge amount of time. Okay, so we're going to start, and comments coming in. So again, thank everyone, participants, people who are tuning in. So I'd like to welcome everyone to the webinar, Crisis Management for Families in the Time of COVID-19. This webinar is hosted by the Commission on Hispanic Rights and Responsibilities and the Section on Civil Rights and Social Justice of the American Bar Association. My name's Carolyn Orzak Schoenberger. I'm the Executive Director of the Schoenberger Public Interest Law Foundation and I'm very honored to be a member of the Commission on Hispanic Rights and Responsibilities of the American Bar Association. So the world has become a place that we never could have imagined. If we were experiencing this was the storyline and a plot of a sci-fi movie, we wouldn't have believed the plot. Such is the time of the coronavirus. So the ABA is very proud to present this webinar. We are honored to have an esteemed panel of speakers who are well-renowned and well-regarded in their fields. They will share their wisdom as well as information on the various resources available. But please be advised that the information here should not be construed as legal advice. And the American Bar Association does have a link on the webpage where legal advice can be given pro bono. So I would like to introduce our panelists, and then we're going to start with Judge Dickler. Our panelists consist of the Honorable Grace Guerra Dickler, presiding judge of the Domestic Relations Division of the Circuit Court of Cook County, and a true pioneer in the use of remote platforms on access to justice. Richard Pena, who's the chair of the Commission on Hispanic Rights and Responsibilities, and a very well-respected, honored attorney practicing workers' compensation law in Texas. Lisa Murphy, an attorney with Chicago Volunteer Legal Services, who is renowned as a practitioner and lecturer in the area of guardianships, powers of attorney, and wills. Moises Hernandez of Hernandez and Reynolds, who is well regarded as an attorney practicing immigration law, and Michael Maciate, who is of counsel to DLA Piper, and is a very well-known attorney in employment law. Each of our panelists will share their perspectives with you for about 10 minutes. Then we will open the platform for questions that can be typed in using the icon on the bottom of the screen. Again, thank you so much for spending time with us and really helping each other work through this time. With that, I'd like to introduce as our first speaker, the Honorable Grace Gatter-Dickler, currently the presiding judge of the Domestic Relations Division of Cook County. She has been the presiding judge since 2011 and a judge on the Circuit Court of Cook County since 1998. Prior to becoming a Circuit Court judge, she was an immigration judge and also an administrative law judge for the Illinois Human Rights Commission. Under the leadership of Chief Judge Timothy C. Evans, Judge Dickler established the first unified Cook County Domestic Violence Court, hearing both civil orders of protection and criminal matters related to domestic violence. She is the president of the Jewish Judges Association and the co-chair of the Language Access Committee of the Access to Justice Commission of the Illinois Supreme Court. As you will see in the presentation, she has been extremely proactive in establishing remote accessibility in family law cases and has received many, many awards, which are too numerous to list. Judge Dickler graduated from Northwestern Law School. She also came to the United States from Cuba in 1961 as a very young child as part of Operation Pedro Pan. Thank you so much, Judge Dickler. We're looking forward to hearing what you were going to say.
Thank you, Carolyn. It's a pleasure to be here today. And the big challenge for me in presenting is that I know that there are participants from all over the United States, and particularly in family law, it's a very localized type of practice. I think more than in a lot of different areas like immigration, for example, family law is really state by state. But I will try to let you know what we have done since the pandemic to try to ensure that the courts remain accessible to litigants and attorneys alike. So what happened, next slide, please. So what happened was on March 13th of 2020, our Chief Judge, Timothy C. Evans, who's actually the Chief Judge of our unified court system, which is a really big court system. It has over 400 judges. He was foresighted enough to realize that we needed to do something with regard to the pandemic. And he talked about reducing court services, really limiting operations at that time. And originally, the first order that was entered was going to limit operations in the court to essential court operations, and everything else should be conducted telephonically or through video conference. And you know, as we all know, the whole balance here is public safety versus accessibility to the public. Next slide, please. So originally, we thought that we were just going to be at a reduced operation level for approximately 30 days. Even that seemed like an extraordinarily long time because, as you know, in the family area, people just can't wait. It isn't like if you have, for example, a business dispute, which could probably wait, but you have families that are in crisis, living together in a very difficult situation. So from the beginning, I decided that we needed to remain as accessible as possible. And we have, at this time, entered a total of 23 administrative orders that allow us to progress with the court in as much a normal situation as possible. Could I have the next slide, please? I'm not seeing the presentation on the screen.
So sorry, Judge Dickler. We're having a few technical difficulties. Just one moment.
Okay.
Judge, can you maybe talk about some of the cases that you're hearing remotely while we try to deal? Oh, wait.
Sure. So I'll proceed with, oh, thank you very much. So we've entered approximately, actually 23 general orders. And I think the important thing to bear in mind through this whole process is that we really have to be flexible in terms of the orders that we entered. We are in a brave new world. None of us have been through this before. And so an order that we thought might have been a good idea really needs tweaking and so forth. So there's already been a few situations where we've amended orders that we entered because as we progress, we realized that perhaps something would work a little better doing it a little more differently. So we have made sure that we can continue doing everything, including prove-ups to terminate a marriage, whether they be by agreement or by default. The only problem with new cases, though, is that our sheriff, which is a different constitutional office, is only serving emergency lawsuits. So we may not be able to get service of process on new lawsuits that are not emergencies, but we are doing the very best we can in that. Next slide, please. So to date, we are addressing remotely emergency and interim orders of protection, temporary restraining orders. We're rescheduling some court dates automatically. We have stayed all body attachments for non-payment of support or maintenance because, as you may have heard, the situation in the jails is just prime for COVID. So we don't want to arrest people during this period of time. We've instituted means for attorneys to be able to file all sorts of motions. And the motions, we've instituted briefing schedule on non-emergency motions that include a response and then a reply. And upon getting everything, the judge then is allowed to make a determination as to whether they want to rule on the pleadings or whether they would like argument or even a hearing date. Next slide, please. Next slide, please. Okay, so the one thing that we have kept, I'm sorry, there appear to be some difficulties with the slides, so I'm just going to proceed. There are a few problems with the orders that we've entered insofar of accessibility to the court. The main problem that we are encountering is accessibility of self-represented litigants to the courthouse. We've been having absolutely no problems with attorneys. So we are working on that, and we are hoping that we are able to increase the accessibility of self-represented litigants. The problem with that is that we have no way of contacting many of them. Attorneys, of course, are easy to contact. self-represented litigants are not. So we have had all sorts of remote court proceedings, as you can see on the slide now. We've had contested hearings, emergency hearings, orders of protection, custody evaluation. Let me talk about that, because that is something brand new that we instituted. So in a lot of our cases, we have to appoint an evaluator to give an opinion as to custody. And the evaluators, who are always mental health professionals, either psychologists or psychiatrists usually, were a little bit concerned about conducting remote proceedings. I've just entered an order that allows, at their discretion, for that to take place. So what I would suggest to anyone else in the country that is attempting to enter orders is the important thing is to definitely bring to the table, before you do so, the stakeholders of that would be interested in what is going on. Because if not, you're going to be entering orders that really may not fill the need of what you're trying to do. So we have been working at this. I was just in a very long Zoom meeting with our chief judge and a number of the judges. I don't know what happened with Dr. Fauci today, but I do know that our governor said yesterday that the time for the state of Illinois to peak may not be till mid-June. And I believe that if that's the case, I don't know if he's going to extend the sheltering in place order, but it really is incumbent upon us to ensure the safety of our judges, attorneys, and litigants. For example, our main building in Cook County is a 30-story building where court is held. That has courtrooms all the way from the concourse level, which is the lower level, to the 30th floor. Expecting the same amount of traffic that we had before coming into that building is just not reasonable, and I think would put a lot of people in danger. I think our chief judge, who is very forward thinking, stated today that he's not sure when or if we'll ever be able to go back to the way things were, at least not in the foreseeable future. So again, I think that flexibility is something that's really required. And you need to be flexible, not only in terms of the cases that are brought remotely, but also the other services that one is able to afford remotely. For example, most of our mediations are now being done remotely. We have mediators that have volunteered to do pro bono mediation on cases 2 hours at a time so that they can try to resolve issues. Our parenting education classes, which used to be provided both in person and online, are now 100% online. We've made sure that our interpreters are available online and through Zoom. And we've also made sure that the court reporter's office is available through Zoom as well. So that's basically some of what we've done and what you need to be concerned about if you have not instituted remote proceedings. Also, don't forget services such as Chicago Volunteer Legal Clinic, which is going to be presenting and other services that are available to help self-represented litigants. Thank you.
Thank you so much, Judge Dickler. And you have a lot of wonderful information that's available, that will be available to everyone today. Our next speaker is Richard Pena, who has been honored in his home state of Texas for his work representing injured workers for more than 30 years. He's the past president of the American Bar Foundation, the State Bar of Texas, and has been on the board of governors of the American Bar Association. He is rated AV by Martindale and Hubble and is currently the chair of the ABA Commission on Hispanic Legal Rights and Responsibilities. He is a graduate of the University of Texas Undergraduate School of Law. Richard has been widely recognized for his leadership skills as well as his excellent work as an attorney, and he is the renowned author of Last Plane Out of Saigon. Thank you, Richard.
Well, thank you, Caroline. And also thank you for being the moving force behind this webinar. And I'd like to thank all the audience for participating. These are uncertain times at the minimum. And I'm going to talk to you. My goal today is to talk to you about workers' compensation. It is a very unique area of the law, but basically what it is employers get workers' compensation. It's like insurance. They buy insurance, and it's a social contract that every state has, and every state is different. Their workers' comp is a little bit different, but the social contract is that the employers buy the insurance, and the theory is that if a worker is hurt on the job, that worker will get medical treatment, get weekly benefits, 70% in Texas, and get some sort of settlement or impairment rating, go back to work, and everything is fine. Unfortunately, it doesn't always work that way. Medical benefits are, in Texas, it's what's called reasonable and necessary, and that is always a dispute. Every state has a different set of laws, but the principles are the same. Injured worker gets hurt, they get medical benefits, they get temporary benefits while they can't work. What we've seen in our, we've seen it for injured workers is that there are many hurdles, and it's very difficult to navigate all of the hurdles. The complexities, at least in our state, the laws are many deadlines, many procedural landmines. I've represented lawyers, I represented a judge who couldn't figure workers' comp out. And our focus on the Hispanic Commission is Spanish-speaking lawyers or Spanish-speaking injured workers. And that they have additional problems with language barriers, employers not paying them well. I spoke with the Workers' Defense Project last week, and they said times are drastic for our immigrant community because they're in, many of them are in construction, they're in hotels, food services, they're getting laid off. What we found is that workers, especially our immigrant workers, if they get hurt on the job, they don't want to be fired, so they just keep working. But their situation can be very dire because they get to a point where they can't work, they have no money coming in, and most of the time they have a family. Now, when they get temporary income benefits, if they're taken off of work, there's a certain percentage, in Texas is 70%. Can I have slide 1, please? Well, maybe slide 1 will catch up with us. But at any rate, it's 70% of your average weekly wage. There you go. 70% is of your average weekly wage is what you get. And so the question is, what is your average weekly wage? We have the average weekly wage is usually what you make a week. But you can add, like in the picture, You had this lady we had Starbucks. She worked for Starbucks, and she made very little, and it was part-time, so her average weekly wage was not very high. And remember, the temporary benefits are based on that. Well, but the law also says whatever benefits she gets. So this lady had Starbucks at the time would allow their workers to drink 5 cups of coffee during the shift. Well, she happened to drink the most expensive coffee you could find, so you multiply that times 5, and she was making as much money. I mean, we increased it almost twice because of that very factor. The real world of workers' compensation is that it's littered with denials. You've got doctors that every case that we have is a denial. And it's the claim is either denied on it didn't happen, it's denied on medical. Insurance companies have doctors that say he has a sprain. For example, we had a 24-year-old recently that lifted 250 pounds. He has a herniated disc. MRI show it. He's young. Insurance carrier says, well, it's a lumbar sprain because he had degenerative. It's degenerative disc. Well, he's 24 years old. And the problem is that the 24-year-old doesn't get his medical treatment until we go basically to a designated doctor, go to court and get it. Can we have slide 2, please? The ABA, that's an article that the ABA posted on its journal. They saw how problematic workers' compensation was in our state, and they did an investigative report. Terry Carter was the reporter. I was interviewed, others were interviewed, and they wrote this scathing article, and that's what it is. Denials, delays, and medical help, all of that is being denied. I particularly was thrilled with the article in the ABA Journal that had one of my checks that I had received for payment, which the check was for 2 cents. And 2 cents. Because in Texas, the effort has been to eliminate claimants' lawyers by greatly reducing the legal fees that they're going to do. So these are drastic times, they're very uncertain times, and it's compounded for immigrant community and for all workers right now. I don't have to tell you that there's some jobs that are more critical, and especially for being exposed to COVID-19, front lines, firefighters, EMS, hospitals, even construction. We're seeing a lot of construction outbreaks, and we have a lot of immigrants in that area. Can we go to slide 3, please? Now, slide 3 is, if there's anything you're going to take away from this, take slide 3 away, because don't expect you to remember or know much about workers' compensation. It is kind of complex in the sense that there are many rules and regulations, and they vary from state to state. But one of the things that somebody asks you, what do I tell an injured worker? Well, this is what you tell them. Give notice to the employer as soon as you're injured. As soon as you're injured, because if you don't give notice, the carrier is likely to say, well, you didn't get hurt on that day because you didn't tell the employer, and their deadlines. Get medical treatment as soon as possible. You're fighting not 1 for treatment, but 2 for denials, because the longer you take, the sooner that the carrier will claim that you didn't seek treatment, so you weren't really hurt. Get a workers' compensation lawyer as soon as possible. Many deadlines. Don't quit your job, because jobs, if you quit your job, it may cut off your temporary benefits that you're entitled to. And finally, and very importantly, give these people all of the resources that you have available. We have a sheet of paper that we give to our injured workers. Now, let's talk about COVID-19 and how that interacts with what you're trying to do. You may have heard about the presumptive, that if you are in a certain front lines, that it is presumed that you contracted COVID-19 while at work. There are 5 states that have passed that presumption, but you can think of workers in 2 groups. One is the frontline workers, EMS, hospital workers, police, and you can think of the other groups, that's everybody else. Unfortunately, from everything that we can gather and what other lawyers throughout the country are saying, if you're in the first group, you have a better chance. If you're in the second group, you probably will not get workers' compensation. And I think it's going to be, everything is in flux, but it's going to be very difficult to get workers' compensation covered, given the denials that the insurance carriers give frequently and not in every case, because we would have the burden of proof to prove by preponderance of the evidence that it was contracted, and with the expanding population getting COVID-19, it's going to be pretty hard to do unless you have that presumption. So for your takeaways, give the clients the options, expect the denials, try to get them all their options, understand that workers' compensation is going to be a hassle, deadline driven. And finally, Gail Collins, who is the op-ed reporter for the New York Times, came to Texas and she did a book about Texas. And there was a chapter on workers' compensation in her book. And she interviewed me, and that's one of the quotes. But the takeaway was that the title of the book is Don't Get Hurt in Texas. Well, that can expand to other states as well. Every state is different, but they're getting closer to Texas rather than, which is constricting the benefits for injured workers rather than expanding them. And this is a very difficult time. I echo what the judge said, is be flexible in these times. And I would impart everybody to be strong and be not afraid in these times. You are lawyers.
Thank you, Richard. Our next speaker is Michael Maciate, who's of counsel to DLA Piper in Dallas. Michael provides advice and counseling on labor employment matters to entities of all sizes, ranging from Fortune 100 companies to startups on a wide range of business and employment-related issues. He counsels clients in litigation, commercial transactions, corporate compliance, ethics, and risk management matters, and he also does high-level internal investigations. Among his many honors, he was named a Texas Rising Star by Thomas Reuters and received the Randolph Williams Excellence in Pro Bono Award. Michael is a graduate of St. Mary's University Law School. And I'm going to mention that I hope we can have a few questions towards the end. So thank you, Michael. We don't hear you.
I guess I need to work on that mute button a little bit. I was just saying thank you, Caroline and Richard, for the wonderful work that you guys do on behalf of the Hispanic Commission for the ABA, and it's a privilege to be here today. Let me share my screen. So I'm going to kind of high level this for everybody. Obviously, we've experiencing an unprecedented situation with COVID-19, and employers and employees are experiencing these issues kind of together. We'll skip a couple slides here, but the first bit of benefits that were provided to employees was an expansion of paid leave via the FMLA for parents who have children who are home from school, since all the schools are shut down around the country, as well as paid sick leave for up to 2 weeks in the event that an employee finds themselves needing to care for an employee, to care for a family member who either has COVID or is exhibiting symptoms of COVID. So certainly for those of you that are employees out there, please ask your employer about benefits regarding the FFCRA, either expanded FMLA or paid sick leave. For employers out there, by no doubt you guys have seen the news regarding the various stimulus packages that have been passed by our government with a nice handle called the CARES Act. The main program that employers are looking at is the Paycheck Protection Program, or PPP. And another option, if companies are not seeking the PPP program, is to defer their Social Security payroll tax deferrals for up to a year, and we'll talk about that here in a bit. For some reason, I'm having trouble with the slides. Give me 1 second. So if you are in a small business and you were looking for the PPP program, generally be aware that you would be eligible for up to 2.5% of your monthly payroll for a 1-year period. If you were not in existence as a business last year in 2019, the eligibility calculation period would be January 1st, 2020 to February 29th, 2020. And again, it's 2.5x or 250% of that payroll. How do employers and companies calculate those costs? Well, very simply, you look at compensation, whether it's salary or wages, pay for vacation or sick leave. There is a provision for the payment of like severance or separation benefits. There's also a provision for the payment of retirement benefits. As a general rule, the costs that will not be eligible are the dollars for salaries that are in excess of $100,000. And once again, if a company is looking to benefit from the PPP, they won't also benefit from that salary deferral that I mentioned before. Once the loan is applied for and received, we're generally exploring options with companies about starting up a separate bank account to house the funds, because eventually those funds could be forgivable. And so you want to be able to trace those funds and where they're going and what they're paying for. And here's a list on the left-hand side of the screen of the appropriate uses of the PPP loan proceeds. Generally speaking, 75% of those proceeds should be used to pay for payroll costs, and we just talked about that. And then the other 25% should be used to pay for things like utilities, rent, mortgage obligations. One note here that hasn't been widely discussed is the opportunity for sole proprietors to apply for and receive these PPP loans as well. So that's something for those of you that are sole proprietors to look at. So the interesting element of the PPP program is the forgiveness element. And if certain things are adhered to, the forgiveness is 100%. So if 75% of the proceeds are utilized for payroll costs, the other 25% are utilized for the covered expenses, within an 8-week period from the date that the proceeds are provided, then those proceeds can be forgiven. There is going to be some documentation, and We're still waiting on the SBA to provide some definitive guidance on the forgiveness process. And so all we can say is make sure you keep your documentation, make sure you're able to verify what those funds were used for and when, which then goes back to perhaps having a separate bank account to house those funds. Obviously, because of the economic impact of COVID-19 and the mass shelter-in-place orders that we have across the country, employers are having to explore different options to cut costs. Some of those options include furloughing employees for a period of time, and other options include layoffs. Please bear in mind that if an employer is seeking to benefit from the PPP program and benefit from that 100% forgiveness, there is a deadline of June 30th of 2020, whereby if an employer has reduced headcount before that date or reduced hours in a significant way, those hours and that headcount needs to be restored in order to maximize the forgiveness.
Hey, Michael, we need to wrap up just a little bit because you have 2 more speakers. Thank you.
Oh, for sure. Sorry. So overall, everybody, you guys can consult the slides on your own. These are, again, unprecedented issues. Everybody, we're in this together, both employers and employees. And, please consult the slides and consult an attorney if you have questions about how any of these should work for you. Thank you.
Thank you very much. Our next speaker is Lisa Murphy, a staff attorney with Chicago Volunteer Legal Services. And yes, I'm speeding up just a little bit. Lisa is experienced in probate law, handling complex guardianship issues such as guardian ad litem cases, helping families with estate planning. She is also an excellent professor, and she actually trains other lawyers on probate matters. She's experienced in residential and business matters. She's a John Marshall graduate and also is the president of the board of the DuPage Legal Aid Society and former chair of the New Lawyer Division of the DuPage Bar Association. Thank you, Lisa.
Thank you so much. Good afternoon, and thank you for having me. Got a lot of information to cover in a small amount of time, so I'll really just hit the highlights. But I wanted to talk a little bit today about planning for families and some estate planning tools that are available for families during these times when they're concerned about things like illness and disability. So I'm going to really just hit the highlights of planning for disability and illness, like I said, with powers of attorney, planning for death with a last will and testament, and then making plans to make sure that children are cared for should someone be unable. And as Caroline said, I'm an Illinois attorney, so a lot of this information is really state specific, but I think the general principles are pretty universal. But I may use terms that are more Illinois specific. So just keep that in mind as you go through. So first I'm going to talk about powers of attorney. This is the one thing where I have clients or family and friends that ask, if there's anything I should do for my estate plan, what should I do? My response is always to get powers of attorney in place. Generally speaking, there are 2 types. There's healthcare and property, and kind of just like they sound, they cover healthcare decisions and property decisions. Some states combine these forms, so keep that in mind, but generally speaking, each state's going to have something to cover both areas. And it's a way to, while you're still healthy and still mentally able, you can appoint someone to make decisions on your behalf. So a healthcare power of attorney or agent would be able to speak with doctors, make treatment decisions, make decisions regarding life-sustaining treatment, view medical records, anything that the principal would be able to do. Similar with property, the agent can access bank accounts, pay bills, file income tax returns if the principal is not able to. And generally, these forms are going to last until the principal dies, unless they write otherwise in there. You could shorten that term if you don't want it to last that long. And a lot of states have these forms readily available online, so they don't necessarily require someone to meet with an attorney to draft the forms. Somebody can go online. In Illinois, we have a great website called Illinois Legal Aid Online, where people can go on, they go through a series of questions, and it'll actually draft the form for you. But it's a good tool, and you want to appoint, the principal wants to appoint someone they trust to make those decisions, but it's something that you can, like I said, you can put it in place while you're still able to, while you're still healthy, to make sure there's somebody there to make decisions for you. Should you become unable, whether it's because you have some kind of a health crisis or age, takes its toll. But the key is that it's a document that's signed by the principal. So that person has to be of sound mind and memory. And states differ as far as the definition of this, but generally speaking, someone has to know what they're doing. They have to know what they have, what kind of decisions they would want made on their behalf, and who they want to make those decisions. What comes up a lot in my practice, and we'll get a call from somebody that says, my mom's in the hospital, the doctors won't talk to me because they say I need a power of attorney. Can you do a power of attorney for me? And my response to that is, well, you need to have mom call. And if mom's not able to call because she's, mentally incapable of making those types of decisions, or maybe she's unconscious, then it may be too late for a power of attorney. But if, somebody's still able to make decisions, and maybe they're just in a hospital, so they can't get into an attorney's office, that's okay. There are workarounds. But the key is that if somebody can't have a meaningful conversation with an attorney about these types of decisions, they shouldn't be signing a power of attorney, and you shouldn't be drafting it for them. And of course, check your state for the witness and notary requirements. I know in Illinois, there are only certain people that can act as witnesses for these forms, so keep that in mind. And why is it important? It's important because the idea is that you're appointing someone that you trust with the hope that they will do kind of what you want when the time comes for them to act. It also avoids someone having to go to court to ask for this type of authority to make these types of decisions. And it provides a guidance for families. Usually if an agent is acting with a power of attorney, it's because something bad happened, so they may not be at their best making decisions like they normally would. So a power of attorney form can provide a guide for them as far as what you might want. I know in Illinois, our powers of attorney are a broad grant of power, and then you can limit them. Some states do the opposite, where it's a small power and you can expand it. But you can, at least in the healthcare form, you can put very specific guidance as far as whether you want to be kept on life-sustaining treatment or what types of medical procedures you want. So it's a guide rather than having your family kind of guess as far as what you would want. And next, I talk about planning for death with a last will and testament. I will go over this really quickly because I feel like most attorneys have an idea of what to do with wills. Oh, sorry, 1 second. And generally, it's going to create a plan for your property after you die. If you don't have a will in place, then the state will create one for you, which may not be what you want. You can use a will to name guardians for minor children if there's somebody that you particularly want to care for minor children. And then you can appoint the person that you want to manage your property after you die. It can also be used to make specific gifts, disinherit heirs, if there's someone that you don't want taking property. And most importantly, like I said, you can name a guardian for minor children. Same as the power of attorney, somebody has to be of sound mind and memory in order to sign a will. If they can't say what they have or who their family members are or who they would want to receive their property, then they shouldn't be signing a will. I'm going to jump ahead to planning for children because I know I'm running out of time. And I want to make sure we hit this because we're getting a lot of questions from parents on what do I do to plan for my children if I get sick or if I have to leave the state or the country. And guardianship can be a good tool because it gives custody and decision-making authority to another adult that's not a parent when the parent's not able to make decisions, but it does not terminate parental rights. So these types of guardianships that I have on this slide are specific to Illinois, but your state probably has something similar. And in your materials, I included the form for short-term guardianship, because this is a really useful tool. If you have a client that maybe is worried that they might be deported, or they're worried that they might get sick and not be able to take care of children, or maybe they have to leave the state or the country to take care of a family member, they can appoint a short-term guardian that they choose to take care of their children. In Illinois, a short-term guardianship is good for a year. It does not require going to court, and the form's available online so that you can fill it out and have it readily available when the time comes, or if hopefully you don't need it, but then it's available and somebody's in place to take care of the child when you're not able to. And then I've included these are more Chicago-specific resources, but if you're in the state of Illinois, IllinoisLegalAid.org is a really good tool with online forms that are available. It helps clients fill out the forms, gives them specific instructions for what to do and how to complete them. And then there's some other legal resources. And if you have questions, feel free to put them in the chat and we'll get to them at the end.
Thank you so much. Thank you. So our last speaker is Moises Hernandez, who's a principal at Hernandez and Reynolds, who was born in Mexico, came to the US at the age of 7, is a graduate of Loyola University School of Law in Chicago, and handles a variety of immigration matters, including deportation defense, helping people become lawful permanent residents and citizens. He is on the board of Latinos Progresando, an outstanding nonprofit in the Little Village area, and recently joined Loyola University School of Social Work as an adjunct instructor in their bilingual online master's program. Thank you, Moises. Looking forward to hearing from you.
Sorry about that. Everybody can hear me? Somebody give me a thumbs up. Okay, great, thank you. I also have a lot of material, so I will try to race through it very quickly. I have 3 major points, well, 2 major points and 3 if we have a little, if I can fit it all in. Well, first, the pandemic, what it's done for our clients, as Caroline mentioned, I work in immigration law exclusively. It's heightened the anxieties that many of the immigrant families are currently already struggling with, given the increased confusion regarding the state of the immigration law. Part of this is due to obviously the complex nature of the law, but also a lot of misinformation or poor information out there, and also obviously the environment of increased hostility towards a lot of immigrant groups. And I selected these topics based on a lot of the questions that my office gets from either our existing clients, prospective clients, or other attorneys or organizations who work with immigrant populations who regularly approach us for advice. So my first piece of advice that I give all of our clients and that I share with you as attorneys to make sure you recommend to your clients is that immigrant families should have a detailed emergency plan. First, immigrant families I'm defining as any mixed status families. That's families with people with lawful status and people without lawful status, or anyone with non-citizen with legal status in the US who may be subject to grounds of removability or inadmissibility after traveling abroad. For example, some legal non-citizens who may have issues are anyone who has any type of criminal conviction, anyone who may be a permanent resident but has resided outside of the US for an extended period, or anyone in lawful status who may have a violation of that status. For example, a student who has failed to maintain enrollment in the original institution that sponsored them, or an employee who's here on a labor visa who has changed employers without obtaining first the proper authorization to port that employment visa. Any of those individuals may fall out of status even though they were here lawfully in the US. A very common misperception that a lot of my clients have and that in the community is that if I've been detained by immigration authorities or sent to immigration proceedings, removal proceedings as they're known, that means that I'm going to be ordered removed. Meaning, if I'm arrested by ICE, I'm going to be deported. And especially as attorneys, it's really important that we educate people that deportation proceedings, the same as any other proceedings, does not equal a final order against me. This is the beginning of a process in which any party summoned before a court can petition for relief. So many individuals who are summoned before the immigration courts may qualify to apply for some kind of relief that would either grant them ultimate authorization to remain permanently in the U.S., or in the alternative, give them the opportunity to depart under a voluntary departure order, which gives them time to put their affairs in order and depart, and also a form of departure with the U.S. from the U.S., which is not an order of deportation, which has legal consequences or possible future remedies. Okay. As a general rule, individuals who have been in the U.S. more time are more likely to be eligible to petition the court for some kind of relief in immigration removal proceedings. In fact, according to DHS's own, that's the 2018 population estimates report, and these were using numbers from 2015, out of approximately 11.96 million undocumented individuals in the U.S., DHS estimates that 5.9, that's almost 6 million of those individuals have been in the U.S. already from 11 to 20 years, and that approximately 3.6 million have been in the U.S. more than 20 years. That means that out of approximately 12 million individuals, more than 9.5 million may have been here in the U.S. more than 11 years, which in many instances, if they have spouses, children, or parents with status, make them eligible to request certain types of relief if they should be before an immigration court. So really important to emphasize to immigrant clients and their families that they may have relief should somebody in the family be detained who is without status or has violated a status. Now, what should an emergency plan have? First, it should be based on current and accurate information. So any family member should consult an attorney and get a current assessment. Many times I see clients who said, well, we were told 10 years ago that I couldn't file to legalize through my US citizen wife. And that may have been accurate information back then, and it no longer is. They may have other options. So any plan should be based on accurate, current legal information, and of course, sharing all relevant facts with their attorneys or prospective attorney. And relevant facts include, obviously, the non-citizen's full immigration history, any history of arrests with documentation. Obviously, as you all know as attorneys, somebody's account of what happened in court is not a reliable source of legal information regarding the resolution of that matter. So in immigration practice, that always means obtaining the certified disposition for any previous case they've had before any court, resulting from an arrest or any criminal charges. And of course, any receipts of any prior petitions that they may have had in the past, or that their parents may have had if they had a prior immigration petition when individuals were, when the individual was still a minor. And of course, that develop a very detailed and specific plan that includes all passports of family members, complete and accurate birth certificates. It is amazing how often you see birth certificates that are just inaccurate. The most common one is maybe dad wasn't added on, or a name is incorrect. You want to advise clients that they should be taking care of all that stuff in advance. Marriage certificates, divorce decrees. In the worst case scenario where a family member may be detained by ICE and may be in custody, and the family has to retain an attorney, and they're petitioning the court either for the individual to be released on bond or for the individual to request some form of ultimate relief before the court. Trying to get all this information and documents together in a time of crisis is really, an additional hardship on families. So my advice is really that immigrant families, mixed status families, should have a very specific, well-developed emergency plan in the event that a family member is detained. That's my first topic. The other one is cannabis legalization. As we know, cannabis has become legalized in many states. For anyone who is not a U.S. citizen, the message is stay away from cannabis or the cannabis industry. Cannabis is still a controlled substance under federal law. An individual maybe will not be arrested or convicted for cannabis possession. However, under immigration law, you can be asked about any use, possession, or work in the industry, and cannabis can be detected in a medical exam, which is routinely part of the legalization process, both in the US and through consular posts abroad. You do not need to have a conviction for immigration to use this as a factor in denying your application. Admitting sufficient elements of the crime under federal statute, such as possession of cannabis, is sufficient to have your application denied. In addition, drug trafficking is still a federal crime, even if what you are doing is participating in a legalized cannabis industry in your state. For federal purposes, immigration will still consider that a violation of trafficking laws. And you don't have, if you are a US citizen petitioning your spouse can be denied because the government could make the argument, and they will, that you are, that intending immigrant has benefited from the drug trafficking industry. The petitioning spouse works for a cannabis distribution facility, and that means that they are still participating in an activity that is not recognized as legal, in fact, is considered illegal by the federal government, and the individual will be denied. A conviction is not required. The argument, the government arguing that there is a nexus with the drug trafficking industry, that they have reason to believe that the person has benefited from the drug trafficking industry, is sufficient. And especially when the individual is processing for legalization from abroad and they are denied on that basis, there is nowhere to appeal that decision.
Moises, this is fabulous. We need to sort of wrap up.
Well, I think that would be enough. I won't go into the other topic, which is the public charge.
Public charge could easily be that. Yes, so basically, I was going to wrap up by talking about the need for an emergency plan. You've covered that. Thank you. Want to recommend people that do a well-being check with your clients. Everyone appreciates it. I don't know how many people can stay for questions, but I really want to thank our panelists. This has been fabulous. I wish we had more time. Thank you so much. A great service that you've done. And I want to thank the people who have stayed with us. I guess I do need to ask, can we stay a little further to answer questions? If someone could, Skip or Ali from the American Bar Association, can we stay a little bit longer?
Yes, you can.
Okay, well, okay. So I would like to, at this point in time, there's a lot of material, including some material that I have that are on the website that will be available to everyone. Very important information. As an immigration practitioner, no one really knows what is going on with the public charge. So if I could ask if there's some questions. Again, we had a question on guardianship. Lisa, would you want to basically go over that? We'll just ask for more people if they want to ask questions.
Sure. The question I had was, if I'm giving guardianship of a child and the parent dies, do I become responsible for that child without the court getting involved? And this, I'll preface this by saying this is going to vary quite greatly state to state. So I'll answer in response to Illinois. It's likely that if you were given a short-term guardianship, for example, it's likely that if a parent dies, you are going to have to change the type of guardianship that you have in order to make sure that you're able to take care of the child until they turn 18. So in Illinois, if you're a short-term guardian and the parent dies, you would need to petition for what's called plenary guardianship, which is a full guardianship until the child turns 18. You have to provide notice to the relevant family members. If there's another parent that's still living, that parent is entitled to notice. And the law is probably going to favor a parent taking care of the child. So it's going to depend. To give a lawyer answer, it depends. But it's likely that you would need the court's involvement after the parent dies.
Thank you, Lisa. I would also want to mention, if anyone has questions, sort of now is the time. I know that we're running over, but as long as the American Bar Association lets us do so, we can handle a few more questions. I do also, as a former prosecutor and proponent for dealing with consumer protection, I would recommend that people consult with lawyers, that they don't consult with notaries. They don't, there are some really great, like Latinos Progresando, community-based organizations that are super in dealing with some immigration matters, but leave it at that. I don't recommend that. I recommend people talk to an attorney, at least get advice, and then perhaps they can then follow up on their own. There are some things that you can do, as was pointed out. Legal Aid Online has great resources, but I've prosecuted too many cases dealing with notaries, and especially in the immigration area, can deal with any terrible results. So we don't seem to have any additional questions. Is there any participant who wants to say something before we leave?
I would like to ask a question. Moises, you were going to get into the third topic. It looks like we have time for that. Could you? That sounded intriguing.
Okay. Well, okay, let me just pull up my notes. It was just I was going to say just a few things about the public charge. I think there's been a lot of coverage in the media about it. It went into effect on 2/24/20. That's after the Supreme Court said certain states no longer had an injunction in effect, etc. But a few things broadly, because a lot of the information is inaccurate. First, it applies primarily to individuals who are applying to obtain lawful permanent resident status. It does not apply to all categories of immigrants. For example, U visa holders, a lot of victims of crime visas, TU. It does not apply to those individuals. And people who already have permanent asylees, refugees, I'm sorry, those are two other categories that it does not apply to. Individuals who already have their lawful permanent resident status, it does not apply to those individuals as well. Individuals who are applying for citizenship, it does not apply to those individuals as well. Although, of course, when you apply for citizenship, you can be asked if you've collected any public benefits. If they are benefits that you were properly eligible for, say, based on your years of contribution to Social Security, those should not be, a negative factor against you if you're collecting. If, say, you worked legally and you collected a benefit you were eligible for, that is not a bar. But it is. I mean, it does represent, I think, an attempt by the administration to, I think, exclude more people by scrutinizing as many avenues for potential denial as possible. And that's not crazy conspiracy thought. I think the immigration bar generally agrees that we've seen a lot more hostility in applications, requests for evidence that has already been submitted, requests for evidence that was never asked before, just, a general trend to make the application process extremely onerous and difficult, and sometimes just absurdly obstructionist, as it is not uncommon for immigration attorneys to receive 2-3 requests for a document that was provided with the original application.
So if I can, sorry, go ahead, Judge.
So it was interesting because this whole public charge issue is not something that family law attorneys are that knowledgeable about. And I've had a couple of cases in family law where it's been a relatively short marriage, and usually you wouldn't think that there would be any maintenance obligation. And then lo and behold, because of the public charge provision that has, when you're asking for someone to come over and you're agreeing that they will not be a public charge for about 10 years, because of that provision, people that may have been married 2 or 3 years now find themselves on the hook for 10 years of maintenance. So it's something interesting where the two areas of law really intersect.
Caroline, we're not hearing you.
Oh, sorry. One of the questions that I'm going to ask Michael is, if someone is undocumented, can they apply for unemployment? And then I'm going to ask Richard about workers' comp.
Yeah, that's a great question, Caroline. I think there's a difference of opinion amongst practitioners, whether you're talking to employment practitioners or immigration practitioners. And this public charge issue is sort of the cloud that hangs over it. You know, my understanding, and you know, one of the areas that this presents itself is various states have what they call work share programs, where employers are applying for unemployment benefits on behalf of their employees as a way to reduce costs. So an employer, for example, is trying to reduce their costs by some 20%. They might be able to supplement those wages by unemployment benefits through the state, as well as the bump up that is provided in the CARES Act from the federal government. Whether that imperils an immigration practitioner, I mean, a foreign national's you know, opportunity to remain in the U.S. or imperils their ability to successfully apply for a benefit is largely unknown. I'd love to hear Moises' thoughts on that, but from the employment side, you know, I know it's happening. To be honest, this is one of those where I have to give the answer that Lisa provided, which is it depends.
Well, I'll address that. I think my answer is yes, the literal answer, it depends. But I think my understanding is that several questions, it depends, the things that it depends on are, when was the employee working with authorization? Someone may not have status yet, but may have had a work permit. Because and again, you're the expert on this, it's a little bit like an insurance program, right? I'm contributing and I dip into it when I need it. Is that correct? The unemployment system?
Sorry, I was muted. Yes, that's correct. The employer is paying into a trust fund to provide benefits to employees when they become.
My understanding is, was the employee working with authorization at the time, and are they eligible to seek out employment lawfully right now somewhere else? Say they become unemployed. I think that's my understanding of the kind of basic rule of thumb of how immigration looks at it. If the employee was working with authorization and is not free, or is not able to seek out lawful employment at this time, I think there's an argument that they may not be eligible for it. We did have one question, an immigration question, that if it's all right with the group, I'd like to answer. Can everyone see the question, or should I? Well, I'll read it. Is that all right?
That's fine.
Okay. The question is, if a citizen is married to an undocumented resident who was locked up for drugs but not convicted, how likely is the success of a petition for the person to become a legal resident? So first, that's an excellent question, and similar questions are pretty common in my practice. A lot of criminal attorneys reach out to us with issues like this one. It's a very fact-intensive issue, but the answer is, the fact alone that you were arrested and charged at some point is not itself sufficient basis to be denied adjustment, you know, without a conviction. However, because of the type of application that this is, and the government is allowed to look beyond just whether there is or is not a conviction, and moral character is always that issue, the government can and will the applicant absolutely must disclose this arrest. Failure to disclose it and then the government discover it in itself is pretty much killing your application. So it must be fully disclosed, and I would say the individual should request the file, the arrest records, all documentation in the file, if it still exists, and present that to an immigration attorney before proceeding with any application. Because, as I mentioned earlier in my presentation, the government having reason to believe that you have benefited in some way from drug trafficking can be sufficient. There is not a requirement that there be a conviction. So that's my...
I want to jump in on 2 points. Number one, that in Illinois, frequently people will say get supervision as a sentence. And if you complete the terms of supervision, it could be terms, it could be a year. It is no longer a conviction in Illinois, but it is still a conviction under immigration law. So people must be counseled about that, and attorneys have to look for that. The second thing is dealing with unemployment, is that there are certain work visas, like the H visas where you work visas, and if you lose your job, it's going to be very, very hard, number one, to get another one in this climate. Number two, you have work authorization to get unemployment. So I just wanted to mention that. Richard, can I ask you about if you're undocumented, what is the situation? And I recognize it's just in Texas with workers' comp, if someone's undocumented.
If you're undocumented, you're definitely eligible for workers' compensation. We have a lot of undocumented workers. What we've seen is that the employer many times gives a Social Security number to the employees. And so boom, you've got a Social Security number. I had a hearing once where we went to hearing and we were getting ready to wrap up a settlement, but they needed a Social Security number. And my client says 999999999. And everybody looked up and I took them outside and I said, time out, wait a minute. And I asked him, that's not a real Social Security number, what's up? And he says, oh yeah, the employer gave that to everybody on the job. But it doesn't preclude workers' compensation.
Carolyn, I was just going to say, just highlight something really important that you said is, because I did not say it and I probably should have. A conviction under immigration law is a much lower bar than under pretty much any criminal statute I've ever known. Remember, immigration is not a criminal proceeding. It's still a civil proceeding. So the standard is much lower for the immigration authorities to determine that something constitutes a conviction, including many diversion programs.
We just got a question that if the conviction took place 15 years ago, does that matter?
Great question. Forever till the end of time. Yes, there are no statute of limitations in immigration, nothing. And unfortunately, there is a lot of bad information in different immigrant communities that circulates that after 7 years, something is gone, after 10 years, 15 years. If you've been separated from your spouse for 7 years, there's an automatic divorce, all of these things. So no, absolutely not. I have had someone denied citizenship for what they answered on an application in a foreign country in 1954, a box they checked incorrectly.
So if I can ask Judge Dickler, just a question dealing with, again, moving a little bit from immigration into the family law area. So now you're hearing cases. Are there cases coming up where people have lost their jobs and cannot pay child support? Many of us are, again, trying to check on clients. That may be a question that that lawyers get asked, even if they're immigration lawyers, labor lawyers, etc. I have to pay child support. I lost my job. I'm not getting child support because my ex-husband lost their job. What do you think the best advice would be?
Well, in Illinois, and again, so much of family law is state specific, but in Illinois, even with those exigent circumstances, if a payor does not file a motion to reduce child support, they're going to be required to pay the amount that was originally ordered, even though they don't have a job or their income may be much lower. So you want to advise a client that they need to file a motion to reduce child support right away if they've lost their job, or a court is not going to be able to go back retroactively. And because we are now under reduced court appearances, we have not had a lot of cases yet that have been filed requesting reduction of child support. But I am anticipating that that is going to be one of the largest percentage of cases that are going to be brought to us, unless miraculously this whole thing turns around very quickly. You're muted.
No, I got it. Thank you. So Lisa, regarding guardianships, now I know there's a mechanism. We had a horrible situation where someone had a 17-year-old daughter, both of them were in the hospital. They came out, mom had to go back in and died. So right now in the courts, is there the ability, hopefully you would plan for this, but is there your ability in a fact situation to do an emergency guardianship?
Yes, well, I can speak to Cook County because I know the Cook County Court has been very cognizant, and a lot of the collar counties here in Chicago, of emergency situations, and especially in guardianships, that there may be a need to get into court very quickly. And in general, in normal circumstances, there are mechanisms to get into court under an emergency motion the same day if you need to. And at least the Cook County Court has been pretty good about doing virtual court appearances, and they did put a procedure in place where you can contact the court directly, get a court date within, I had a colleague in my office that got a court date within 24 hours to hear a petition to extend a temporary guardianship. But I imagine that if there's a situation where a guardianship is needed right away to continue medical treatment or for whatever reason, that if the courts are trying to be open to as many people as they can if they're needed urgently. So there's a way to get in. At least in Cook County, I imagine that most states are trying to make themselves accessible. Like Judge Dickler was saying, accessibility is really key. And at least for our clients, it can be difficult to manage the virtual court appearances, but I know the court's working on that too, to make it more accessible.
Judge Dickler, do you want to add anything?
No, Lisa covered that.
Oh, okay. So we were asked a question about what is it that people attending today, what is the best piece of advice other than be safe, use your mask, wash your hands, that we could take away if all of the participants could perhaps share with us, something that we want our attendees to go ahead. I'm going to start with you, Melissa, since you were the last one to talk.
If you are a non-US citizen or a citizen who is petitioning someone else, stay away from cannabis use or any involvement with the cannabis industry, regardless of its legal status in your state.
Thank you. Thank you. And Lisa, we did have a question on guardianship. If you agree for someone else to be the guardian, can you stop it at any time? What would be your response to that?
Yes, I believe there's a way to revoke it if you've appointed it would depend on the state as anything and depend on the circumstance. With short-term guardianship, you could revoke it or have it stopped. And I believe in the form, I'd have to look at the form again, but I believe you can put in a specific time frame. If you only want it to last, if you don't want it to last the full year, like a short-term guardianship in Illinois, you can put a shorter time frame.
Could you possibly put in when I terminate it in writing?
Yeah.
Okay.
And the form that's in the materials actually even has a trigger, so you can put in a specific time for it to start. It doesn't necessarily start immediately. You can have a springing start date, so that if I'm determined incapacitated by a doctor, you can put that in there. You don't want it to start right away. Same with a power of attorney, although there are reasons why you would and wouldn't want that in there for a power of attorney, but that's a longer discussion. Thank you.
Thank you. Michael, what are your, exit thoughts that you want to share with us, please?
Yeah, I think as we start to relax the shelter-in-place orders and, in a phased way, reopen the workplaces, I think now more than ever, employers and employees need to work together to ensure the safety of the workplace. Employees need to self-regulate, as far as if they have symptoms of COVID or they are living with someone with symptoms of COVID, they need to make that known to their employer. And employers need to be vigilant with protecting the workplace. We're talking, there's no rules around this. We're we're making it up as we go, but we do know that, you know, the way we used to be is going to be different, and we need people to be patient about that. So if the coffee machine isn't available because we don't want a bunch of people touching it, everybody just needs to be patient. Same thing with the water machine, same thing with other sort of high touch points within the workplace. So patience and flexibility are the buzzwords of the day.
Thank you. Richard?
From the standpoint of workers' compensation, is people should take away that there are many deadlines, there can be many deadlines in the different states, and they start from the minute the injured worker gets hurt. So that is very important. Injured worker needs to give notice, a verifiable notice immediately, and I would recommend they get a lawyer right away. From a big picture standpoint, and to those that are left watching, I think we need to understand that lawyers are needed now more than ever. And we should take that and run with it because our country needs us.
Thank you. Thank you. And Judge, what would you want to share with us, please?
Well, I'm going to be a little bit more philosophical. I think we need to be kind to one another because these are very, very difficult times for everyone. We need to be flexible, and we need to give people a little bit more wiggle room. We're all going to make mistakes, and let's just get through this and realize that it's probably not going to ever be the way it was before, sadly.
Do you predict that there is going to be now a greater impetus to do what you've been doing as a pioneer in the area of remote access to the courts? Do you think that that's something that's going to increase?
I do. I definitely do, because I think this is a lesson well learned. We have to be able to use everything that is available to us technologically. And many of us are not that young, and it's not that easy to take up things that we never even knew existed when we started our practice. But I think this is a lesson well taught, and it should be well learned.
Thank you. Thank you. Anyone have some last thoughts that that they want to share with other panelists and with the people attending? I'm going to again just give the basis of my past as a consumer protection advocate about being careful out there, that there are scams not only for hand sanitizers, that there are masks and things like that, that this is really a time to be careful, not to panic, to be flexible, to be patient. I think these were all very, very wise things. I'm going to add something to what Moise said, and this is just in general. Don't sign everything. That in the event that you are stopped, in the event that by immigration, in the event that someone wants you to sign a paper relieving them paying child support, patience, and I also would counsel that it's important for people to read what they sign, and no one has to sign everything right away. I think that's critically important. So let's see if we have any more thoughts. Anyone want to add anything more? Judge, did you want to?
I just wanted to thank you, Carolyn, and to echo what Richard said previously. You've done an excellent job, and it was when I first heard what this was going to be, I couldn't even conceptualize so many different areas, but it's been fabulous, and thank you for inviting me.
Well, you're very kind. Thank you. So I want to thank everyone for joining us today, and we can stay on a little bit maybe and talk about general, our views on this. I want to thank everyone who attended. Greatly appreciate your time, and please be careful, be safe, be patient, be kind. I like that. Be kind out there. So at this point in time, you've been sent a link where you can access all of the materials that people are talking about. There was so much more that could have been talking about. But again, thank you to the American Bar Association. Thank you, Richard, the chair of the commission, and also to Allie. And thank you, and be safe. So with that, Allie, I'm going to turn that over. Allie is is our technical leader, as is Skip. I'm going to turn everything over to you for next steps. So